Som 1, 2. May I have your attention, please? Good morning, everyone. The organization committee welcome you to the second Brazil-Japan Litigation Society seminar. I'm Daniel Machado, PhD student for Tokyo University. I'll be the person guiding you through our seminar today, introducing speakers, keeping time, and giving short notices. Um, First, for our opening ceremony, I'd like to invite a few professors to take a seat in the front. First, Professor Masato Ninomiya from São Paulo University, please. Applause. Um, Judge Kazuo Watanabe. Applause, please. Professor Fatima Bonassa from ESA. MASP. ASP. Okay, sorry. Professor Yoshikazu Yamaoki, Director of the Faculty of Law of Shinshu University. Professor Floriana de Azevedo Marques Neto, Director of the Faculty of Law of the University of São Paulo. And Professor Antônio Rodrigues de Freitas Jr. from São Paulo University. Now I give the floor to Professor Freitas. Please go ahead.
Okay. Well, good morning, everybody. It's a great honor to be able to have you all here with us this morning in the second initiative to put together academics and legal practitioners from two friend universities. Thanks to the initiative of Professor Masato Ninomiya, we have a formal partnership between the two universities, and in order to make this partnership something relevant for our academic research and academic exchanges, we are discussing and confronting experiences and researches and perspectives from different fields of the legal studies. The main idea is to discuss litigation and culture. We have two different countries, very different from the standpoint of the rate of litigation and the nature of litigation. So this is the reason why we are in the second meeting, and we also have the perspective to have some other meetings in the seconds in a row. Professor Floriano de Azevedo Marques, Professor Yoshikazu Yamaoki, Professor Fatima Bonassa here, join us. I would like to thank the Cultural Association of the Law Practitioners of the State of São Paulo. In your name, Dr. Fatima. I also would like to thank the partnership with the Instituto de Direito Comparado Brasil-Japão, that is here represented by our I used to say he's an institution for us, Professor Kazuo Watanabe. I also want to thank the initiative committee to help us, Dr. Cecilia Zaparoli, register the presence and the partnership with the Grupo de Estudos Jurídicos Brasil-Japão. And probably I will forget to answer some other partners, some other friends that helped us to make this dream come true. This is a dream, and we finally very happy and excited to have you all this morning with us. But especially, I have the duty to thank very, very warmly to the help that we received from the organizing committee. The most important one I have to emphasize with Dr. Yuri Nabashima. I thank you very much for your help. Without your constant help and openness, this meeting wouldn't be possible, for sure. But I also want to ask, to thank for, once more, Professor Cília Zapparoli, Professor Yoshiaki Yamaoki, again, Professor Sotaro Maruhashi, which is a friend of ours, and my dear Akio Shimamura. Akio Shimamura is a former professor. We have the honor to hold a course together, a grad study course together, and it was a wonderful experience because we could discuss, and we had the opportunity to receive in this course also two wonderful lectures from Professor Kazuo and from Professor Masato. It was a wonderful experience for us, unforgettable. So, thanks for joining us again. Dr. Bruno Takahashi, a great friend of ours, that is very helpful, partner of all our different initiatives. Mr. Daniel Machado, thank you again for helping us. Miss Erika Yamashita, where's Erika? Okay. Erika Yamashita, and Miss Ana Carolina Yonui, and also Tiago Trentinella. All these people, all of them worked with us very tough work in order to make this possible and to make it as friendly as possible. Well, Mr. Dean Floriano, this is just a welcome and the first remark that I had the duty to offer. I think it's for you. Thank you very much for coming.
Good morning, Professor Kazuo Watanabe, Professor Masato, Doutora Fátima Bonassa, Professor Antônio Freitas, Professor Yoshikatsu Yamaoki. I am very proud to welcome in our university our friends at Shinsu University and to welcome everyone here for this seminar. We have a long history of partnership with Japan, and Professor Masato, Professor Kazuo worked hard to reach this level of partnership, and we want to be closer to Shinsu University. There could be no better opportunity than a seminar about litigation. In Brazil, we have nowadays a level of litigation, and this is a great problem for us. We appreciate the Japanese experience in reducing litigation levels, and we have a huge interest to learning about it. ADR, plea bargain, process agreement. These subjects are very important for us. And learning about this, it's central for our evolution in process, in criminal law, labor law, and every kind of branches of law. I wish we all had a good working days today and tomorrow, and I am sure we will have a great seminar. Thank you.
Professor, você falou? Professor Yamato. Ok, professor Yamato.
Bon dia. Good morning, ladies and gentlemen. I greatly appreciate for the hospitality shown by Professor Florian and Brazilian friends. As you know, we held the first meeting of Brazil-Japan Litigation and Society Seminar with the cooperation of University of São Paulo and Shinshu University in January 2018 in Japan. And in this February, we published the bulletin of Shinshu University, in which 16 attendants summarize the results of the first meeting. And today, we will be holding a second meeting of this litigation and society seminar. Today, we will discuss various problems related to labor and social securities under the theme of cultural diversity and global challenges. Tomorrow morning, we will exchange opinions about the ADR in various problems mainly related to labor and family. And later on, we will focus on criminal litigation and law and policy on the retirement process of the elderly. Since working style reforms and promotion of reducing overtime work has been one of the most important policies of Japanese government, we could say that this seminar is timely and very, very important for our Japan. Finally, I want to express my gratitude to Professor Freitas, Professor Ninomiya, Professor Watanabe, and Professor Shimamura's cooperation for enable us to hold this seminar. I am looking forward that this seminar will be beneficial and productive. Thank you. Obrigado pela gentileza.
Eu acho que mais alguém quer fazer uso da palavra? Professor Massato? Professor Kazuo? Eu acho que a gente nós estamos aqui. We're just trying to make some announcements. This seminar will be broadcasting in streaming by YouTube, and the address is FDUSP space audiovisual.
Yes.
So this is the address. We're going to make this more clear in some of the slides over there.
Okay. Okay.
And I think we're just in time to start.
Next, we're going to move to our first section. I would like to thank all the professors for our opening ceremony. Thank you very much. I'd ask you to take your seats back. Thank you. Applause, please. Um, so the first session will be cultural diversity and global challenges. This session goes from 9:15 to 10:30. The chairman will be Professor Carlos Alberto de Sales from the University of São Paulo. Uh, he's, he's a little bit late. Uh, Okay, so the chairman hasn't arrived yet, so I start calling for the other participants. First, Judge Kazuo Watanabe, please, one more time. And next, Professor Hernani Oda from University of São Paulo, please. And next is myself. So since we don't have a chairman, should I start? Should, Professor Sales was supposed to be the chairman, so should I just start with it and then when he arrives? Okay.
So sorry for this short delay from the chairman, my dear Professor Carlos Alberto de Sales. But I think in order to be in time as much as possible, we have a lot of different sessions in the sequence. I would thank Professor Kazuo Watanabe.
A ordem ela está invertida. O professor vai falar por último. Primeiro Hernani, depois eu.
Okay. Also thank to Daniel Machado and Professor Hernani Oda. We're going to change just the order of the presentations, and I ask for Professor Hernani Oda to start. Thank you very much.
You have to press it.
Have to press this. Okay. Is this on? Okay. Thank you, Professor Freitas, and I really appreciate the opportunity to be a part of this seminar. Now, I'm actually not a legal scholar. I'm a sociologist, so I'm not sure how well I fit in this seminar, but it's an honor to be a part of it. Anyway, so I guess the reason I was invited to give this talk is that, well, the subject of this seminar is related to cultural diversity and maybe cultural comparisons. So I thought I could talk about a little bit about this notion of culture and how culture can help us or not help us understand social phenomena. So I guess most of you know this better than I do, but when you talk about practices in different countries, it's very tempting to think about cultural difference as a kind of explanation for all kinds of things. So you probably know this a lot better than I do. It's, for instance, when people compare litigation behavior in the United States and Japan, there's this old explanation that, well, the Americans go to court more often than the Japanese because they're individualists, and the Japanese have some kind of cultural, collectivist culture. So that would explain the differences. Well, of course, there's a lot of doubts and skepticism about this kind of explanation, as there should be. So, at least since the 70s and the 80s, a lot of people are very uncomfortable with this kind of facile use of culture. and they have tried to come up with different kinds of explanations that usually dismiss even the role of culture. So, it's not culture that explains why different people in different countries go to courts or don't go to courts. Maybe it's because they just have different systems that are more, they are easier to use in the United States. So in Japan, maybe there are some structural reasons like less lawyers and things like that. So it's not that people have different cultures, it's just that they have different resources and they calculate the best means that they can use. And sometimes the best means are different. Well, I guess that was an improvement. And I think we need that kind of criticism, and we need to question how we use the notion of culture. But I would say that maybe dismissing culture as an explanation factor would be a little too much. So maybe there is something in between that we can reach if we don't just dismiss culture, but try to understand culture in a different way. And I'd say that's what's been happening not necessarily, it's not something that's restricted to legal studies or litigation studies, but I'd say that's a tendency that we can see in sociology more generally. So, like in the 60s, it would be very often, we would see very often people saying, people behave in a certain way because of their culture, because in this country they have this kind of culture, in that country they have this other kind of culture. And this kind of explanation was very popular in the 50s and in the 60s. And in this kind of interpretation, culture is seen as something very, that's very internalized by people, as kind of a moral commitment that people have. Culture is something that we value, that gives our whole lives meaning. And culture is something that's present in every different aspect of our lives. So I mentioned the litigation aspect, but you could also say that, well, Americans are individualist, and that affects not only litigation practices, but how they behave in traffic, how they live their family lives, their workplace, at school. So culture is everywhere, and it's a very cohesive and coherent set of principles. So that was how we used to think about culture in the 50s or the 60s. And then we had a very strong criticism of that kind of interpretation. So like I said, maybe it's not culture, maybe it's just people's interests that actually drive people's behavior. So we think about, well, how many lawyers are there in a country, how this system works, how can I benefit the most from this kind of system? Maybe that's how we should think about culture, like strategic behavior. And that was a very important contribution that we had in this maybe 70s, early 80s. And as I said, it was a way of kind of dismissing culture or undervaluing its role. But then, as I said, maybe that was going too far. So in the 80s and the 90s, we see a very clear tendency to try to rehabilitate culture, to try to, maybe we can see culture in a different way that is not as, essentialist or rigid or simplistic as before. Maybe we can come up with some kind of different concept. And that's basically what most sociologists did in the 80s. So they tried to say, well, if we just think about strategic behavior, maybe people don't think so strategically most of the time. Maybe we don't always calculate how things will play out. Maybe we're not fully rational, we're not fully instrumental, we're not aware of all the implications, of all the factors and of all the variables that go into making decisions. So we're not going back to that superculture that makes us do every kinds of things that we do in our daily lives, but maybe there's something a little automatic that we just take for granted and that help us navigate our social lives. So it's not as rigid as culture used to be, but it's also just strategic and instrumental. And I guess that's the kind of culture that has been emphasized and analyzed in the past 20, 30 years. So just to give an idea of what that means. So what's this? Okay, it's very nice to say that, oh, you talked about culture in a different way, but what does that mean actually? Well, there are all kinds of examples. So for instance, think about a very prosaic example, like hospitals trying to equip themselves. And the general idea is that, well, hospitals buy some kinds of equipment and some kinds of resources because it's going to help them treat patients or because it's going to make things more efficient. And so the cultural analysts will say, well, not necessarily, because oftentimes hospitals buy really fancy equipment that doesn't really help them treat patients better, sometimes doesn't even help them get more clients. They just do it because they have internalized some kind of preconception that that's what hospitals should do. Hospitals should have the best equipment or should do something like that. They don't really calculate. They don't have a clear strategy. It's more like automatic behavior. They just think that's what's supposed to be done. And so that's kind of the reasoning that's behind this new notion of culture. And one thing that's also important is that since it's not something that's really internalized and coherent and like a moral commitment, culture doesn't have a very it's not an overarching structure. It's not something that you will find in family life, workplace, litigation, or arts. Some culture is now seen as something very specific, very particular to some areas. So, education has its culture, family life has its culture, but there's really not something like we could call Brazilian culture or Japanese culture or American culture, like something like individualism. Oh, American culture is very individualistic. It affects people in all their lives. Cultural analysts are not very comfortable with that kind of statement anymore. So maybe there is something that overlaps among different domains. Maybe there isn't. That's really up for empirical debate. But the starting point should be, or at least for now it is, to focus on specific fields and specific areas. So that's, I'd say that's a very big difference from the way we used to think about culture and the way we try to do that. Now, of course, this is not a perfect program, so I'm simplifying things a big deal. There's a lot of debate, there's a lot of conflict, but I'd say that's the general tendency. And just to give an example that's maybe a little closer to what we're doing here, I'm not going to talk about litigation. It's not my field. You can do that way better than I do. But maybe we can see a little bit how some sociologists nowadays are trying to think about, for instance, Japan or Brazil in terms of cultural analysis. And so instead of thinking about, well, Brazil is like this, Japan is like that, or this country's like this and this country's like that. I guess most people are trying to find some specific areas and try to deal with how, what kinds of images, what kind of symbols that people activate when they navigate those areas. So just give one example that's, I think, relevant to Japan and maybe indirectly relevant for what this seminar is all about. There's a very recent study by a Japanese sociologist called Tsutsui Kiyoteru. So, and he basically analyzes social movements in Japan that make demands about human rights, especially human rights against discrimination. So his basic question is, well, in Japan, in the specific area of discrimination and human rights, there are some symbols, there are some ideas that we could call cultural. So, for instance, he says there's this myth of homogeneity, ethnic homogeneity, or national homogeneity. So, the idea that we're all the same, Japanese are all the same, they belong to the same race, or etc. Now, most research in the last decades basically say that's a lot of BS. I mean, that's just not true. But what's interesting is that Tsutsui says, well, It's not true, but it's interesting. It's interesting because it's something that people discuss when they talk about race. Okay, they don't discuss it in all aspects of their lives. They don't think about it when they go take the bus or do something like that. But when they are dealing with race and ethnicity and maybe relationship with foreigners, that's something that they have available to them. So in that sense, it's cultural. But unlike the old days, it's not something that dictates how people behave. So there is this idea, this notion, people have it available to them, but it doesn't mean that, well, people will necessarily believe in it, and doesn't mean that people will behave in a certain way because of that. It's something that's there, and it's something that has a role. One of its roles, he says, is that it makes it a little difficult to make demands for human rights against discrimination. So if you have that idea that we live in a homogeneous society, it can be a little difficult to make demands about for minorities to call out on the government and say that they're being discriminated. The government can always say, no, but there are no minorities in Japan. So it has a role. It's not just BS. It is BS, but it's not just BS. But one of the things that Tsutsui also says is, well, that's not the only symbol, that's not the only narrative, that's not the only image that is available for people. There are also other different kinds of symbols. One of them, which he says is very important, is the notion of global human rights. So global human rights is also a cultural asset that is available for people in Japan as well. And he goes to great lengths to stress how this notion of universal human rights, global human rights, really galvanized social movements in Japan. And he gives several examples. I'm not going to go into details here, but he gives examples of an indigenous group in Japan called the Ainu. The Japanese, of course, know about this. He talks in great detail about the outcast groups. I'm not going to go into detail, but maybe some of you, even in Brazil, have heard of the expression buraco. He talks about Korean people of Korean descent that also have mobilized, especially since the 1970s. And his argument is basically that, well, there is this culture of homogeneity, but there is also this culture of global human rights. And both of them have impacted how people behave and how people mobilize and act and demand. And so that's how I think cultural analysts like to think of things nowadays. They don't dismiss culture. There is something that we could call culture, but it's very specific. It's very local in the sense that it's very specific to certain areas like discrimination, human rights, and it doesn't have a ready-made result. So because you have this culture, you don't necessarily behave in this way or that way. So there is room for negotiation, and that's what he says social movements do in Japan. Sometimes they have, they benefit from this kind of symbol. Sometimes they benefit from that kind of symbol. And just to be clear, he says global rights are not always necessarily good. For instance, he mentioned that the notion of global rights helped people mobilize and make demands. But for instance, in the case of Korean groups specifically, for instance, one of their recent demands is the right to vote, even though they don't have Japanese citizenship. And he says, well, that's actually, he says that's potentially a good thing, but in this case specifically, global rights have not helped them very much because there is not a consensus about voting rights for foreigners in the global arena. So that has actually maybe hindered these movements in Japan. So I think that's also an interesting thing. The same cultural aspect or the same cultural symbol, the same cultural idea can have very different results for sometimes the same group. And let's see, I have only 5 minutes. I think I don't want to bore you too much, especially because you have much more interesting things and more concrete things to talk about. Just to mention, I'm not going to go into details again, but for instance, there's a very, I think, compatible kind of analysis being done about Brazil and the Brazilian experience of discrimination. Just to mention a name that I think it's worth looking up, Graziela Moraes Silva is also a sociologist that deals with racism in Brazil and how cultural ideas, cultural symbols influence that, and how the notion of global rights also influence that. And it's interesting because she says in Brazil we have a like kind of the opposite social symbol, like racial mixture, racial heterogeneity, but that doesn't mean that it's Brazil is one thing, Japan is the other thing. What's interesting is that even though those symbols may be very different, the processes can be very similar. So we work with different symbols, but the processes, the negotiations, the demands, sometimes they can be very similar. And that's also one thing that cultural analysis in recent years has taught us. Instead of just categorizing different countries or different experiences, we can see how they interact as well. I guess that's the main point that I wanted to make. I mean, there are of course many legal scholars that also make these same points. We have a lot of interaction between sociology and legal studies now. I think someone mentioned the Law and Society tradition here. That's a tradition that has very close connections with sociology. They publish legal scholars that also publish in major sociological journals. So I think it's really an exciting time to be working with sociology right now, and also taking a look at what's happening in legal studies, because there's a lot of exchange interaction. So I know I'm not probably the best person to address you about this, but I think if I can only stress again that there is a lot of things that can be exchanged, and there's a lot of interesting dialogue to be made, then I guess I hope I can make at least this small contribution. But thank you for your attention.
Well, first, thanks for Professor Oda for the explanation. I would like apologize for my delay today. São Paulo is not always an easy city. I think even never an easy city. It's a very difficult city. And okay. I want to also to say hello to Professor Watanabe, Oda, and Professor Machado. And now I will announce Professor Daniel Machado from the University of Tokyo.
Thank you. I was planning to use the screen today, PowerPoint, but since everyone is not using, I found out today, I'm giving that up. And my slides, they're not at the beginning of the handout, the handbook. You have there on page 42, from page 42 to page 48. So, like, if you want to follow the presentation, please refer to those slides. In recent years, particularly since the Supreme Federal Court of Brazil rendered a decision recognizing same-sex unions in 2011, the Brazilian judiciary has played an increasing role in the field of family law. Family law in Brazil has diverged from the civil code, assuming the trappings of a common law system rooted in abstract constitutional principles. Today, one cannot fully grasp Brazilian family law without struggling to understand countless precedents that often point to different directions. I wouldn't say, however, that Brazilian courts are particularly activist, at least in the field of family law. This court decision on same-sex unions was actually the pinnacle of a long and relentless process of litigation caused by a chronic dysfunction in the Brazilian legislature, which, despite of the striking social changes since the 90s, has vehemently refused to conform the legislation to the new reality of the Brazilian society. In contrast, for a long time, the Japanese judiciary seemed to be marked by passivity and subordination to the legislature. As a matter of fact, until very recently, there was no decision holding family law provisions unconstitutional. That doesn't mean, however, that Japan has not been struggling with diversity in family law, nor that Japanese courts have not played a relevant role in shaping the law to changing social needs. Today, I will talk about what are the challenges facing Japanese family law today, most of them already overcome in Brazil, and I try to demonstrate how, in similarity to the Brazilian case, legislative stagnation has given rise to a host of rulings overturning well-established precedents. First, to understand Japanese family law, it's of utmost importance to look back to its history. Japan also belongs to the civil law tradition. Its first civil code dates back to the end of the Meiji era and was drafted under stronger influence from French and German law. However, even though many provisions were borrowed from other legal systems, the family law of the Meiji Code was tailored to the Japanese society and family of the time. The result was a family law system completely different from the Western model. For instance, in contrast to the Western model, to the Western legal systems, pre-war Japanese family law orbited around the image of the household, not marriage. In the Meiji Code, rather than a means of establishing family, marriage was regarded as a means of entering an already existing family. The household was centered around the head of the house, called koshu in Japanese. The koshu usually was the eldest male of the family, and the main objective of the law was the perpetuation of the household itself, which was symbolized by the family name recorded in the family register. It was a very feudal-like system. All members of the household had the duty to obey to the koshu, and the koshu on his part had the duty to support or protect everyone within the household. As a general rule, unless it was essential for the perpetuation of the household, women could not become the koshu. Under coverture laws, married women were deprived of their legal capacity. They were subordinated both to their husbands and the koshu. Children were also discriminated by primogeniture. The firstborn son was endowed with the right to inherit the position of koshu, which was the right to inherit the whole household with everything and everyone within it. Adoption, for instance, was designed in the image of marriage. It was a parallel means of entering the household, not like having a son or daughter. Or from the standpoint of the household, it was a means of securing a male heir. For that reason, the Meiji Code provided for a type of adoption called mukoyoshi, literally husband adoption, where the parents would adopt a male under the condition that he married their daughter. One of the legal effects of marriage was that the wife must abandon her maiden name and take on the name of the husband. Thus, it would be impossible to secure the perpetuation of the household or the family name if the daughter simply married her fiancé. Therefore, the solution proposed by the Meiji family code, the old family system, was to have the parents first adopt the groom and then get the groom to marry to their daughter. When looking at some provisions of the Meiji Code, one might have the impression that the Japanese family law was more advanced than most Western countries at the time. For instance, spouses could not only entirely dissolve their marriage relationship, but also divorce through a notification of an agreement without any sort of judicial proceedings. However, in the social context of pre-war Japan, that freedom to divorce only meant less protection to women who could be easily expelled from the household. Also, because adoption would give the exact same rights of legitimate children to adoptive children, it might seem very protective of adopted children. Nevertheless, because of the lack of judicial control to verify whether or not that adoption was in the best interest of the child, it became a legal means of trafficking children. Parents would give, it's something very well known, that in pre-war Japan, parents would give their daughters to adoption to work in geisha houses for money. So in light of this, it's safe to say that we cannot take a single provision apart from the entire or the whole of the legal system and render it advanced to its time. Each provision must be understood within the social context, the context of the society it was designed for. Finally, it's also worth it to mention that pre-war family law was the embodiment of the ruling political ideology of the time. The structure of the household reflected the structure of the nation. Citizens were subordinated to the emperor in the same way members of the household were subordinated to the koshu. It was a sort of, the koshu is the head of the house. So it was a sort of ideological matryoshka doll wherein the Japanese were expected to think of themselves as a homogeneous nation, united by family bonds that stem from the emperor, who was like the godlike koshu of the nation. If in Western countries, religion played a conservative role in establishing family law as a millennial tradition not subject to changes, this pre-war ideology became the basis of family tradition in Japan. After World War II, in view of the ideological role that the old family system had played in turning Japan into a pro-war military dictatorship, one of the main concerns of the US occupation forces was to dismantle that old family system, democratizing Japanese family. In terms of family law, the new constitution, by introducing constitutional principles of freedom to marry, individual dignity, and gender equality, had a meaning tantamount to that of the Brazilian Constitution of 1988. However, the impact of the new constitution was comparatively weaker. In both countries, the old family law was in direct conflict with new constitutional principles. In Brazil, the old civil code was only amended 14 years after the adoption of the new constitution. And in my view, I talk about that in my master thesis, that delay steered family law scholars in the creation of a renewed, constitutionalized Brazilian family law. In contrast to that, in Japan, the family law part of the Meiji Code was entirely formed and enacted within the same year in which the new constitution came into force. The government even enacted a temporary act to fill the gap of 7 months until the act amending the family law part of the civil code came into force. Basically, in that reform, what lawmakers did was erasing all mentions to the household from the civil code. This process is often referred to as the abolition of the household system, Ieseido no Haishi in Japanese. Thereupon, marriage became the center, in the same way as Western models, the center of family relations. And from that time forward, contracting parties did not need to obtain the consent of the koshu, neither the koshu to marry. And as a matter of civil law, the status of koshu no longer existed as a matter of law. Another points of the reforms were that wives had the same rights and duties as their husbands. Married women did not lose their legal capacity anymore. Legitimate children could equally inherit their parents. And if we add divorce by agreement, that it didn't come from that reform, but like they had it already. So from a comparative perspective, we may say that Japanese family law suddenly shifted from an anachronic feudal-like legal system to a trailblazing legislation in comparison to Western models. However, no matter how revolutionary the enacted law might seem to that time, we cannot forget that this was not a voluntary change from within. Formal equality and guarantee of freedom are usually the result of a long and intense social conflict. Obviously, Japanese society had not changed overnight. Thus, the freedom guaranteed by the Constitution was used rather to choose inequality over equality and to perpetuate the old family system. In light of that, we might say that the pioneerism of the civil code cut both ways. In my opinion, with the enactment of a code ahead of its own society, Japanese people were denied the opportunity to fight by themselves, and that might well have delayed the very change envisioned by the Constitution. In the 80s, Japan ratified the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. Japanese society had finally reached the point where it could finally identify itself with its own law. Interstate inheritance provisions were reformed to protect women better. But on the other side, although society was already identifying itself with its own law, it was not ready to overcome it. The reform of inheritance rights of illegitimate children to end discrimination against illegitimate children had to be dropped off after a public opinion survey with results against it. Japanese society only actually caught up with its law and overcame it in the 90s. While Japanese family law didn't have to tackle with issues such as liberalization of divorce or abolishment of coverture laws, Japan began to wrestle with the same challenges being discussed in Western countries. Law on child abuse and neglect, laws on domestic violence, sexual minorities, discrimination of children born out of wedlock, substantive equality, and etc. The fact that the first substantial bill to amend family law was proposed in the 90s evinces that. At the same time that in Brazil, the first legal bill on same-sex partnership was being submitted and immediately shelved by the National Congress, in Japan, the Minister of Justice was approving an outline of the bill that would end discrimination of illegitimate children, correct some gender inequalities left behind by the drafters of the new civil code, and introduce grounds for divorce that do not depend on the existence of fault. And everything was going very smoothly until politicians put their eyes on a series of provisions allowing married couples to keep their maiden names. All efforts suddenly went out the drain. The impetus of the outwardly expired pre-war traditionalist conservatism, far from being withered, yet was strong enough to preclude a whole set of necessary amendments from passing the legislature just because they could not allow married couples to have disparate surnames. Such an amendment to them would cut the last tie with the old family ideology. In the field of comparative sociology of law, there is a long-standing discussion regarding litigation and the role of courts in Japan. As early as 1978, John O'Halley had already refuted the assumption that Japanese are culturally less prone to assert their rights and take their claims to court. Nevertheless, the myth is still healthy and strong, most likely because regardless of the reasons why there is still litigation, it's undeniable that the number of lawsuits filed in Japan is overwhelmingly smaller than in the US or, for that matter, in Brazil. If we consider that the new civil code was comparatively ahead of its time, one might reach the conclusion that there wasn't much room for the Japanese judiciary to intervene. This assumption, however, is unwarranted. In post-war Japan, even though there weren't any decisions ruling provisions of the civil code void by judicial review, the courts advanced the protection of unmarried couples. From a comparative perspective, it's worthy to note that while in Brazil the effective protection of de facto marriage relationships had to wait for constitutional recognition in 1988, in Japan, the courts had already developed a whole legal institution by applying marriage law provisions by analogy. In contrast, in terms of judicial review of family law, Japanese courts were conservative, leaving a wide leeway for the legislature. The most controversial issue litigated was the discrimination of illegitimate children. In the leading case of 1995, the Supreme Court held that the provisions assigning disparate inheritance rights to legitimate and illegitimate children were within the discretionary power of the legislature. We must remember here, however, that at that time, in 1944, the guidelines for amending the code had already been published. Hence, we might say that the court had had reason to wait for a change through the legislature, through the democratic process. That change, however, never came. Thus, despite of this leading case ruling to the contrary, Japanese lawyers just kept suing. However, the Supreme Court, one case after another, repeatedly refused to intervene in this matter. There's something similar happened to the provisions regarding the waiting period to remarry. Article 733 of the Civil Code prescribed that women should wait 6 months before remarriage to avoid the overlapping of the presumption of paternity. That 6 months, it's a 108-day period. However, it was technically excessive because it would impose an 8-day period where there would be no presumption of paternity. In light of this, the 1996 amendment draft suggested that the 108-day period be shortened to 100 days because it suffices to prevent presumptions of paternity from the last and the new marriage from overlapping. However, also in 1995, the Supreme Court held that it was not legislative omission. Again, at that time, there was still hope that the Civil Code would be amended anytime soon. Then, almost 2 decades after the leading case decision and 5 Supreme Court decisions confirming it, in 2013, the Supreme Court finally got tired of waiting and held that even by giving consideration to the legislative discretion, this distinction between intestate inheritance rights of legitimate and illegitimate children violates Article 14, Paragraph 1, the article that provides for the principle of equality of the Japanese Constitution. As you can read from the decision in the handout, the Supreme Court finally acknowledged it. The Japanese mindset regarding family had overcome the code of 1947. Family makeups diversified, the discrimination of illegitimate children became unacceptable, the dignity of the individual within the family is being more valorized. In a rough comparison, if the Brazilian Supreme Court intervened in 2011 to realize something that hadn't been possible through the democratic process in the 90s, the Japanese Supreme Court, at least outwardly, had done virtually the same thing. Also, in the same way, the Brazilian Supreme Court decision of 2011 rippled throughout a host of other decisions based on a clearly renewed understanding of family law. The 2013 decision also reverberated in a few audacious rulings. The first one concerns the presumption of paternity in a marriage where one of the spouses has changed their legal gender, where one of the spouses was born as a female but had their legal gender reassigned through a judicial proceeding. I won't go into details about the law on gender identity disorder because what's important here is that there was a well-established case law saying that the presumption of paternity does not apply when conception is materially impossible. Also, the Supreme Court's take on assisted reproduction was rather conservative, as verified in prior decisions regarding post-mortem conception or surrogacy. Thus, the odds were clearly against the recognition of transgender paternity. However, less than 3 months after the decision on discrimination against illegitimate children, the Supreme Court, in a nutshell, ruled that it makes no sense to allow their marriage, the marriage of people with gender identity disorder, as they're called in Japan, the discrimination. It makes no sense to allow their marriage on the one side and deny presumption of paternity on the other side. While the first case was a rupture with the tradition of prioritization of legal marriage, the second decision, although within the limited scope of a special legislation, made a crack on the wall built by a long-standing trend to biologize parent-child relationships. Finally, in 2015, at the same time, the Supreme Court took a step further in bringing to light what had been envisioned by the failed reform of the Civil Code in the 90s. It also set a limit to the intervention. On the one hand, it overturned the case law on the waiting period to remarry, holding that the portion of time exceeding 100 days was partially voided. On the other, in the same day, the court held that forcing married couples to take on the same surname was not in contravention of the Constitution. was within the discretionary power of the legislature. The surname of the married couple may seem something trivial or outdated an outdated issue in Brazil. In Japan, however, as I have already mentioned, the family name has a powerful symbolic meaning in connection to the traditional view of family. Even in contemporary Japan, it's not unusual to see people discussing the perpetuation or extinction of a family name. In terms of numbers, it is striking that even today, more than 95% of couples choose the surname of the husband. To traditionalist conservatives, the unity of the family is what holds of the family name is what holds the Japanese family together, and changing it would become the last nail to the old Japanese ideology's coffin. At first sight, it looked as if the Supreme Court decision of 2013 on discrimination of illegitimate children would become the landmark decision for a radical change of attitude in the Japanese judiciary.